I'll make sure Mr. Copeland's on the way in. I did nudge the temperature up a little bit. It's a little cold even for me right now. Right. Right. Yeah. Thank you. All right, go ahead, Ms. Tillman. Y'all be seated.
May I speak, Young? I was told that Mr. Melnick been suspended, and I don't want to speak without my attorney.
All right. Let me excuse y'all back again. All right, give us just a second. Yeah, that was brought to our attention fairly recently as well. The thing is, he's going to be suspended for 6 months from practicing. It doesn't have anything to do with this case, but do you have another attorney that you want to engage, or would you like for me to find an attorney, a volunteer, basically?
I would like for you to find one.
All right. Well, I had already, actually, the public defender's office had been in contact with me to try to find somebody without a conflict, and they have found somebody named Charles Engelberger. So let me try to get in touch with him and see if he can get down here and consult with you. Okay.
Okay.
All right. So if you want to just step out for now, and I'll take a recess and see what I can get done. All right.
Getting wilder and wilder. This morning, on the second day that the jury is back, Woody's attorney Melnick has been suspended from practice by the Georgia Supreme Court. He is now suspended and cannot represent Woody, okay? He's suspended for 6 months. There is a whole decision. It's 24 pages long. What I'm going to just do is read the factual background which should give the facts as to what led to Melnick being suspended. So bear with me, y'all. Let's get into this. Again, Melnick is now suspended. Factual background. The following facts were either found by the special master or were established without dispute at the hearing. Melnick has been a member of the state bar since 1994. He received 2 investigative panel reprimands in 2003 and an investigative panel reprimand in 2006. All 3 matters involved violations of Rule 1.4 and 2 involved Rule 1.3 violations. In May 2017, Melnick began representing a client in a matter filed in Rockdale County by the father of the client's child. The father was paying child support via an income deduction order and was seeking a reduction in child support, as well as to legitimate the child and obtain visitation. During that time, Melnick was a solo practitioner with no full-time staff and no case management software. He handled between 50 and 80 cases at a given time and was in court 17 out of 20 days each month. He used a software program to manage his calendar and communicated with his clients primarily after typical business hours. In 2018, Melnick, his client, the father, and the father's attorney participated in a voluntary mediation where the parties were able to reach an agreement on a reduction in child support. However, the parties still needed to agree on visitation and prepare a parenting plan. The parties agreed that the father's reduced child support payment would become effective April 1st, 2018, and that if a new income deduction order was not in place by April 1st, 2018, Melnick's client would reimburse the father each month for the difference between the child support amount paid pursuant to the income deduction order and the reduced amount agreed upon at the mediation. After the mediation, the parties notified the court that they had reached a settlement and would be submitting a final order, so the court removed the case from the trial calendar. The father's attorney emailed Melnick a draft consent agreement about a month after the mediation and asked that Melnick's client begin reimbursing her client for the child support overpayment. Almost a month later, Melnick responded, quote, "Please call me," unquote. The 2 attorneys exchanged a few emails during May and June about a visitation schedule and the amount of the reimbursement. In early August, the father's attorney sent Melnick a revised consent agreement with a parenting plan included. A week later, Melnick responded that the parenting plan was fine, but that he, quote, was not going to agree to a refund of the child support since April. The father can take that up with the child support, end quote. The following day, a Friday, Melnick emailed the father's attorney that he believed that it would not be proper for his client to send the reimbursement to the father's attorney. The following Monday, the father's attorney filed a motion to enforce the settlement agreement. The motion also sought an award of attorney's fees for having to file the motion. Melnick did not send his client a copy of the motion or otherwise inform his client about it. He also did not file a response to the motion because he felt it was, quote, unnecessary. Melnick planned to handle the attorney fees issue at the hearing and believed he could prevail pretty easily on it. The trial court scheduled a hearing on the motion for January 8, 2019. Melnick did not tell his client about the hearing. Because he had a conflict for that date, he emailed a conflict letter to the judge's administrative assistant 5 days before the hearing was scheduled in an attempt to comply with Uniform Superior Court Rule 17.1. While the judge's assistant acknowledged receipt of the conflict letter, Melnick did not follow up with the court to determine if the hearing had been rescheduled. The court conducted the hearing on January 8th. After Melnick was finished with other matters for which he was scheduled to be in court that day, he called the court and was told the hearings were done. He did not ask about the outcome of the hearing and did not contact his client to tell her he had not attended it. Sorry for laughing, y'all. This is crazy. On January 15, 2019, the court issued a final order enforcing the settlement and ordering Melnick's client to reimburse within 30 days $2,820 to the father for child support overpayment, as well as $809.93 in attorney fees related to the motion to enforce. After the trial court issued the January 15th order, Melnick did not notify his client about the order and did not tell her she had to pay $3,629.93 within 30 days and did not send her a copy of the order. The client became aware of the January 15th order when, after the amount she was receiving in child support decreased, she went to the courthouse and obtained a copy of the order. That was also when she became aware of the January 8th hearing and motion to enforce. Melnick never filed a motion to withdraw from the case, nor did he terminate his representation. The client retained new counsel who contacted Melnick and raised the possibility of the client filing a malpractice action against him. Melnick discussed settlement with the client's new counsel, and after the client filed a grievance with the state bar, Melnick paid the client $3,500 and obtained a release. So there you have it, y'all.
I'll tell Mr. Copeland this in a minute, but the attorney is happy to help, but not available until the morning. So I'm going to pass along his contact information to Mr. Copeland, and they can plan to be here in the morning. Question for the state. In the meantime, do you have any witnesses that you could get here that are, like hour-long witnesses whose place in the story does not really matter that much? Like, I think you had some people listed as records custodians and things like that. Any chance we could fill the day with something useful while we've got the jury here?
Judge, the two witnesses that we did have on deck to come next were similarly situated. They were Mr. Slade, whose attorney left town yesterday afternoon, and Mr. Zachary, who said that he is in North Carolina.
Right. So what I'm asking is there a chance you can take some witnesses out of order who aren't integral to the progression of the story that you're telling, but whose testimony you need to get for, whatever reason? Like, you've got some phone record custodians, which I don't know why y'all can't agree to that coming in anyway without a witness, but people like that.
So, Your Honor, the records custodian, for the records that they have to bring in, we do not have business record certs. And so,
Okay.
in prior discussion, I believe that the defense were going to object to those records without having the custodian. Those custodians are out of town, Your Honor. And so we would need time in order to fly them in.
So it sounds like then that we're just going to have to release the jury for the day and pick back up in the morning with testimony, which doesn't mean y'all are all getting released. Maybe we can get some non-jury things done for the afternoon. But let's get Mr. Copeland in here. I'll give him this contact information. Then we'll get the jury in. I'll release them.
Judge, when we approached with the member of the defense, before Mr. Copeland comes in, just with the question.
Come on. All right, Mr. Copeland, during the break, I was able to speak with Mr. Engelberger, and he is happy to represent you. I've got his name and his phone number written down on this sheet of paper, which I'm going to provide to you, and you can call and speak with him this afternoon.
Thank you.
And he is available beginning at 8:45 in the morning. So what we'll do is plan to pick up there tomorrow with you and with him available for you. And in the meantime, between now and then, you go ahead and give him a call and y'all can talk about whatever you need to talk with him about, okay?
Mm-hmm.
All right, so we'll see you at 8:45 tomorrow.
You can give me enough time to talk with him?
Yeah, you can talk with him for the next.
Oh, it's not today?
Yeah.
Oh, so he'll
Yeah, he's available today. He'll be waiting for your call.
I'm not going to have any problem with him, is it?
I mean, I don't know why you should.
Okay.
All right.
You take care.
See you in the morning.
Be safe.
Okay, you too.
Hello.
All right, let's get the jury in, and I'll excuse them for the day until 9 tomorrow. Thank you. Well, ladies and gentlemen, we have had a little bit of a scheduling and procedural hiccup, I guess. So I am going to need to release y'all for the day and have you come back at 9 in the morning to pick back up. We're going to stay and get some other work done, but I'm going to release y'all. I'm going to remind y'all that you are to only decide. We all good? Okay. Decide this case based upon the evidence that you hear in this courtroom. So do not try to find out any information from any source outside the confines of this courtroom. Do not refer to any kind of reference, either old school or online, to try to get information about legal terms, people, places, events, anything like that. Do not talk to anybody about this case. Don't let anybody talk to you about the case. And we will see you all in the morning. Y'all have a good afternoon and evening. And thank you for your time. Sorry, it was a short day today. Y'all are excused. See y'all at 9. Good. Okay, so state, I don't know what tomorrow holds. None of us do about this trial or anything else, but make sure that you've got some other witnesses lined up just in the event that who can get here quickly in the event that, you know, things take some other turn in the morning. Scheduling wise, I think I had mentioned yesterday that next week, I wasn't sure whether it was Monday through Thursday or Monday through Friday. But regardless of what they were told at this point, a juror has a family funeral that they have to travel for on Friday. I've confirmed that. So that'll be a non-jury week in its entirety next week. All right. For us right now, I am hoping that there are some things that we were going to be doing next week that we can just go ahead and tackle today since we all are here anyway. So, well, I think Miss Love, you were, I think, the one that was maybe taking the lead on the PowerPoint issue. And I know you hadn't filed a written response yet, but can you just kind of provide us with what your position is on that? And maybe we can make as in I, can make a decision on that issue.
So, Judge, what I said yesterday and what I was asking the court was the need for the time to locate within the videos of those proceedings, the period that we addressed the PowerPoint. So I had received just some of the transcript of one of the days that we addressed it. And I think that we were addressing the had sort of responded to, it may have been commentary by Mr. Sharp regarding reviewing some evidence the night before. I may have these dates and these times sort of conflated with one another, but I believe that when he brought up the PowerPoint, we had not yet argued it or talked about it. And my memory is that I said.
Get zero down leases now at Bomberton Mazda in West County. Lease a 2024 Mazda CX-30 Select Sport.
Is tell me why you believe it's admissible, and I'll just make the decision. Okay, can you do that? Yeah. Oh, yeah. Yes, Mr. Steele attached it to his motion or supplemented motion. So I've looked at it. And I mean, maybe it would be helpful, Mr. Steele, if you just quickly summarize your position as to its inadmissibility.
Your Honor, this is motion in limine number 49 supplement. It was refiled on August 9th of 2024 on behalf of Mr. Williams. And it was originally filed, and I just, Mr. Adams and I just made it more current.
Right.
But, and that was originally filed on April 17th. 2024. It is my opinion, my memory, and I checked the law and crime video YouTube, that Judge Glanville, and that was a lot of our hearings. I don't know if you watch it, but it was a lot of hectic things, but Judge Glanville excluded it, and the state specifically said they're not going to use it. And to me, I just don't see the admissibility under 401, 2, 3, because slide 1, it's titled YSL versus Inglewood Family Bloods. That is not the name of this case. I don't know why that would go up in front of the jury.
I think there are like 80 something or more slides, and I'm not necessarily asking you to go through the details of each slide, just if you can summarize right now.
Okay.
And it may be that we have to get into the slide by slide position, but
it's basically a closing argument. That's really the summary as I would give it. It is something that the state would, over objection, use in their closing argument. And if the court allowed it, maybe that's okay. But for evidence coming in through a supposed gang expert, who I'll be objecting to in addition, he already testified as an expert, and he's the third supposed expert to testify. But there are things, Mr. Williams' home was illegally searched on the July 15, 2015 date. They have slides in there referencing that. They have slides on information that has not come into this trial on supposed investigation and corroboration by law enforcement. I've never seen a corroboration. It's just like a trial by a theory, and that's throughout. And I'm objecting to the entirety of it. And I don't know why any witness, expert or lay person, would be allowed to use this type of demonstrative device to say, let me explain to you the guilt of these people, when specifically even an expert cannot talk about the mens rea or the intention of a party. That's always within the breast of the jury. And this has multiple people, not just Mr. Williams, joining and committing crimes and saying what their intent was by their association. So I hope I've given you a summary, but if you want to go slide by slide, and a lot of information in those slides are not coming into this trial. The state has not called many witnesses that they said they were going to call, like Mr. Lamar, who's performer known as Rich Homie Kwan. Mr. Carter, a performer known as Lil Wayne, Mr. Williams, a producer performer known as Birdman. They have this information in that slide, and it's just a confrontation clause violation.
All right.
Your Honor, the presentation is meant as an aid for the jury to assist them or allow them to see how it is that Detective Dennis reached the conclusions that we expect will testify about in this case. There are instances where he references hearsay, what would be considered hearsay, but which he is allowed to use to form an opinion and to present an opinion. The slides that Mr. Steele references that have to do with matters that have been excluded from this trial, of course we can see that those would come out and that we would not be attempting to introduce slides that show the inside of Defendant Williams' home as a result of the 2015 search of his home. But there is to exclude the demonstrative that we would be seeking to use through our expert. I don't hear a reason or any basis in law for the just all-out exclusion of information that we believe would be useful to the jury and that Detective Dennis relied on in coming to the conclusion that he did. Much of what is in the PowerPoint does summarize investigations that he conducted. It references persons that he interacted with. It references acts that occurred, investigations that occurred, and again, people that were either self-identifying one way or the other, or that referenced another person as identifying a different way. So we would ask that the court, based on what Mr. Steele has presented, just the fact that he doesn't think that it's admissible or it's a closing argument, that the court deny his motion that we not be allowed at all to use the PowerPoint.
All right. In fairness to Mr. Steele, he's ready to go slide by slide, and I asked him to summarize. So it's not that I asked him to summarize the argument. That's not all he would have to say. But this appears to me to have maybe originally been some sort of a law enforcement briefing. Is that what this was?
In terms of the investigation, of course, started out sort of as you know, them talking and law enforcement, various agencies talking amongst one another and briefing themselves. But in the end, this PowerPoint was something that was used by Detective Dennis in, you know, discussing the investigation with the district attorney's office, and that we believe as well would be useful in allowing the jury to digest pieces of information that he would be presenting through his testimony. Well, I could go through that slide.
So tell me which slides you think you are absolutely concede are not going to be used. I mean, I'm just looking at one right now. It's, I think, slide number 36. It's got a lot of pictures, and it says a rap dispute between Lil Wayne and Birdman spilled over into Atlanta once rapper and YSL 30 Deep leader Young Thug got involved. I mean, how is that not totally conclusory and something that maybe this jury is supposed to be deciding? And that's just, you know, the one I happen to be scrolling onto right now.
Your Honor, the information that is in the letters, in the words rather, that are on the slide, we would concede removing that as conclusory, but Detective Dennis has shared, and I believe would share information regarding what law enforcement learned throughout this investigation as related to not just the Little Wayne bus shooting, but how that related to YSL and members of YSL, and what the artist that goes by the name Birdman, what they learned.
So you're saying all the words would be removed?
Not on this slide right here. I'm not saying all the words, Judge. I want to be really clear. I'm not speaking about all the words. And I don't think that it's necessary for all the words to be removed in this PowerPoint. But when the court asked me to tell or identify the ones that I concede would be, should be removed, I can, if the court permits me the time to go through it and look at those and pull those out, I can do that. But what we had was a whole hog objection to the entirety of the PowerPoint and an assertion that it was inadmissible overall.
Well, I mean, you're I think at this point making the argument that you think it would be a demonstrative aid to. Is this Dennis who's going to be testifying to this?
It is.
And
we can sort of.
so let's look at like slide number 22. We've got people pictured up here who some, but not all of them were charged. I have no idea whether they were convicted. We got lots of shots of, weaponry. There just looks like there's a whole lot that's not going to be appropriate or admissible. If you
So what we're looking at, the slide that I have.
can you pull that mic over towards you? I think some of the people are having a hard time hearing.
So the slide that I'm looking at as number 22, I think is different than the one that the court is looking at as 22. So I'm not certain why. I'm looking at one that has Miss Entrevia Smith, Kelvin Wild, San Antonio Sledge on it. So it's different than the one that the court is looking at. I would ask that the court, if we're going to.
I mean, it's just kind of an example. So I think that maybe if this is going to have to be a slide by slide thing, that y'all get on the same page as to what PowerPoint you are even intending to use, and then you take out all of the ones that you concede and acknowledge are not admissible or would be overly prejudicial under the 403 standard. Take out all the words that you think that is not appropriate, and then get that back to me, and I can look at it slide by slide. But
I think that would be good. I think I would ask for permission to do exactly that, Judge, as opposed to, because yes, I can do that, and I would ask for permission to do that.
okay, I'm going to need that done by Friday.
Yes, Your Honor.
All right, so we can't do that today. We'll be doing that next week. All right, on the motion to suppress recently filed as to Mr. Ryan's statement from 2019, it looks to me, now that it's been further particularized, that there's an argument that he was not Mirandized. I don't know. I haven't seen the statement yet. I don't know if the state's position is he wasn't in custody at the time and therefore Miranda rights weren't required. I'm going to need an answer to that. I also need the statement from one side or the other so that I can have the benefit of actually being able to see the statement. Okay, so y'all get that to me as soon as you can. That ought to be an easy click something and send the email. And is the state, do you, I mean, I assume y'all are familiar with the statement they're talking about, and it was not used in his 2021 trial, but I think, Ms. Love, you've represented that you might want to use it in this trial. Is that right?
I did.
Okay. Do you know whether y'all's position is that he wasn't in custody, or do you know what you're going to be arguing on that?
Just 1 second, Your Honor. We were actually going back and forth, and I'm having trouble getting onto our server. That's what I'm trying to do right now. Are you people that are on the server? I just need to sign into our server.
I mean, I understand that all of this is on the fly at this point. We weren't going to take it up until next week, and now I'm trying to get something accomplished while we've got this unexpected free time. I don't think we need a recess for that. You just be working on that, and maybe I'll ask one of your co-counsel to address the next issue. Actually, I can ask, I can't see all the way around there. Is Mr. Harvey with us? Okay, who's here? Can you speak to, remind me your name? Try it one more time.
Lamar Gardner.
Okay, Mr. Gardner. Okay. Mr. Harvey had filed a couple of days ago a motion to exclude kind of, I guess, what he phrased untimely disclosed co-conspirator or alleged co-conspirator statements. Would you be able to identify specifically which co-conspirator statements he's saying were late identified?
I wouldn't be able to, but if you give me a minute, I can find out.
Okay. And then maybe today would be a good time to start looking at that exhibit list, and on the exhibits that there is not agreement on, kind of figure out, have those been admitted or have those not? Is that something you think we could all tackle today? We could try.
We can do the first part. We are almost finished with it, but we could do a chunk of it.
Okay. All right, I'm going to step off for just a second. Y'all stay here and keep working. I'll be right back.